Alright, so looking at the doctrine of stare decisis, what is this? It's some fancy Latin term. But case precedent and court case reports. Alright, so precedent is a decision that furnishes an example or authority for deciding subsequent cases involving similar legal principles of facts. Alright, remember when I talked about common law and the king, he was making decisions and whatnot, and those were written down? Well, those written down opinions were precedent. So it was written down so that whenever the king had to address a similar issue, he could go back and look at what his decision was in the past, and based on his decision in the past, that precedent, he could make another decision. Alright, so these opinions are written down in what we call reporters. Cases are published or reported in these books, and they're called reporters. Now, stare decisis is, again, it's a Latin phrase, and it means to stand on decided cases. Remember the precedent. Deciding new cases with reference to former decisions or precedents. So the doctrine of stare decisis basically says is that we're not going to overturn precedent unless there's a darn good reason to do so. That's stare decisis. Saying, hey, we're going to follow precedent unless there's a darn good reason to change. Typical scenario. All right, binding authority. All right, case precedent, statute, or other source of law that the court must follow when deciding a case. All right, so we're here in the great state of Georgia. Don't you think that if the Supreme Court of the state of Georgia makes a ruling, that ought to be binding on the rest of the state of Georgia? Yes, that is what we call binding authority. Now, if those people down there in Florida, whatever, if their Supreme Court makes a ruling, does Georgia have to follow it? No. No, because we don't care what the great state of Florida thinks. Okay? But it's persuasive. Okay? It's not binding, it's persuasive. All right? Departures from precedent. Sometimes courts will depart from the rule of precedence, if there's a darn good reason, if it decides that precedent should no longer be followed. Judges also have flexibility in applying precedents. Remember what I said? American law is living law. It can change. Judges can change laws. Okay? They don't have to always follow precedent, but there has to be a darn good reason to do so. But what happens when there is no precedent? These are what we call cases of first impression. Okay? And generally, this doesn't happen often, but with the onset of the internet and whatnot, certainly there's a lot of new laws being created. But when no precedent exists, this is called a case of first impression. Persuasive authority will be precedents from other jurisdictions, namely what those guys down in Florida say. But it's not binding. Public policy is governmental policy based on widely held societal values. Yes, certainly that matters. I mean, don't you think that our societal values here in the great state of Georgia are just a little bit different than what they think over there in California? Yeah. Okay? Stare decisis and legal reasoning. Alright, so we're getting into how to put things together. Legal reasoning is the reasoning process used by judges in deciding what law applies to a given dispute and then applying the law to a specific facts or circumstances of the case. This is IRAC. Issue, rule, application, and conclusion. Okay? And certainly there are all sorts of interesting ways in which to use this.